Welcome to our HOA workshop. Thank you all so much for coming. I'm excited to see so many smiling faces, and I have to say I'm impressed that all of you are smiling. So thank you for coming. I really appreciate it. And I would like to introduce our speakers tonight, Amanda Ashley and Jenny Shamoon with Altitude Community Law. I'm sure many of you, if you've been to our workshops before, probably know Amanda. Amanda is a partner at Altitude Community Law, where she works closely with community associations to provide strategic legal counsel and practical solutions. With more than 20 years of experience, Amanda brings deep knowledge of community association law and a proven ability to navigate complex legal and regulatory matters. Jenny was born in Sweden and moved to the US in 2003 to Michigan and then to California. She attended undergrad in Tucson, Arizona at the University of Arizona, obtaining a bachelor's in law with a Spanish minor. She earned her JD at St. Mary's University School of Law in San Antonio, Texas, where she began her law career. She began practicing HOA law in 2022 and enjoys being a resource for board members and managers. In her spare time, she likes to cook and watch sports, primarily football and soccer. And with that, I would like to welcome Amanda and Jenny, and Amanda is going to start us off.
Yeah.
Thanks.
Good evening. I'm beginning to recognize you guys. No, I was recognizing you before. I'm just kidding. It's good to see all of you. Thanks for coming. Jenny's in the back. She always shows me up because she's, bilingual or trilingual or quadruple lingual or whatever. I just want to point out I like football too. At any rate, so tonight we're talking about not emotional roller coasters, but we're going to talk about governing flags in your, red flags in your governing documents, and then of course things that you hopefully are not doing, but that you definitely shouldn't be doing. And Jenny and I are going to trade off. She's back there helping us out right now by setting up all kinds of goodies. Please peruse while you're back there. There's snacks as well from the city, which we appreciate, but we also have a couple of things that you can pick up and enjoy while you're here. All right, we have a couple of cartoons to start off because those are my favorite things. And there's nothing I like more than meetings.
I have a neighbor in my HOA who's just like that.
Grumpy cat? Yeah. That's weird. I think we all might have that same person. So when we're talking about requirements in our governing documents, now let me start at the beginning. Governing documents, that means your articles of incorporation, your bylaws, and your declaration, or as it's known, your covenants, conditions, and restrictions. Articles of incorporation are the birth certificate of the nonprofit corporation. Bylaws are the operations manual for the board. It's going to set forth what the board's authority, powers, and duties are. And then, of course, the covenants or the declaration, that's going to be primarily what are called use restrictions. So what owners can and can't do with their property, who maintains certain areas, who insures other areas. Most of the requirements that we're going to talk about tonight are going to come from these areas. So certainly the governing documents, but also Kiowa, CCIOA, which I frequently forget how to spell. That's the Colorado Community Interest Ownership Act. It applies to every association that was created July 1st of 1992 with few exceptions, such as like commercial or what are called limited expense communities, which is where you have a cap on assessments, usually a relatively low cap, 400 plus consumer price index, etc., if you're familiar with those words. And then some provisions of Kiowa will apply to what are called pre-Kiowa communities, so a community that's created before July 1st of 1992. So if you are July 1st of 92 to present, that means the vast majority of Kiowa applies to you, your association. If you are a pre-Kiowa community, you would think it meant pre-Kiowa means they don't apply, but it doesn't, unfortunately. For pre-Kiowa, it means only some things apply. And then we have the nonprofit code. Now, Kiowa is under Title 38 of the Colorado statutes, if you really want some great reading, 38-33.3. And then the nonprofit code for Colorado is Title 7. If you're thinking, wow, Amanda, I really had trouble sleeping lately, you can find those on our website, and it will put you right to bed every time, I promise. And then, of course, there's other statutes. So what do I mean by that? I mean that there are things outside of Title 7 and Title 38 that apply to associations. Some of those are federal. You're going to hear us talk about the over-the-air reception devices, which is OTARD, O-T-A-R-D. That applies to satellites, for example, and impacts community associations. There's bankruptcy laws, federal, that applies and affects community associations. There's also like the towing statute. There's towing statutes in Colorado that affect when everyone who is a property owner may tow. That's going to be in a different section aside from Kiowa and the nonprofit code. And then of course the governing documents, which I mentioned already. And then on top of all of these things, and I should have added the plat maps in there too. If you haven't taken a look at your plat maps for your association, take a look. They're hard to read. Most of the time they're illegible, but aside from that, they have little notes on them sometimes about maintenance or insurance or fencing. So if your association, for example, wants to change fencing and you look at your governing documents and you say, oh, it just says we can have fences, take a look at the plat map, because every once in a while it'll say something in there like you can only have a split rail fence. Or you'll pull the development plan with the city, which the developer agreed to, the city agreed to. It doesn't fall under your governing documents, but that's where to find some of that additional information that's going to affect your association moving forward. Then we have rules and regulations and resolutions. Resolutions, policies. You're required to have 9 good governance policies. We'll get to go those later. Rules and regs, architectural guidelines. These are all under the what else category. And then of course everybody's favorite case law, which means that somewhere, somehow a judge determined something and now it affects everybody else that's near there, right? So some of our requirements, like if you've ever done voting by mail and the attorneys have told you, well, you have to send out the whole packet and the letter has to contain this and the ballot has to do this and so on and so forth. Some of that comes from Kiowa, some of it comes from the nonprofit code, but there's also some that cases, because people have sued or corporations have sued each other, a court has made a decision about certain things and that impacts then us moving forward, depending on where we're at and where the decision was made. Okay, all right, I'm going to turn it over to Jenny. She did that surprisingly quickly in the back. And she's going to talk about public disclosures. Do you want me to turn this for you or do you want
The slides?
Yeah.
Oh, if you can.
Yeah.
All right, hello everybody. So we're gonna go now into those 10 items that, or 10 things that associations are required to do. So the first one is gonna be public disclosures. These are things that have to be provided to all owners within the community. So within 90 days of declarant turnover, so after the declarant turns the community over to the owners and now the community will be run by the owners as opposed to partially by the declarant must provide to all owners the name of the association, the name on the articles of incorporation, which is not necessarily always the name that's on the declaration. Sometimes this can vary, which can be problematic but can be resolved. Name and contact info for the designated agent or management company. So they must also provide a valid physical address and telephone number as well. And then the name of the common interest community, which is the name on the declaration. Then the declaration itself, the initial date of recording plus the reception number or book and page numbers for the main document. So that's the primary governing document for the association itself. And then within 90 days after each fiscal year, the date when the fiscal year of the association commences, for some associations, this is the actual calendar year, and for other associations, this may not be the calendar year, but it's generally defined in the bylaws. It must also provide the budget for the year and then a list of assessments, whether regular or special assessments, and list by unit type. It must also provide annual financial statements for the past fiscal year, financial audits or reviews, a list of association insurance policies, including but not limited to property, general liability, association director and officer, professional liability, and fidelity policies. Additionally, must provide the bylaws, articles, and rules of regulations for the association, including any amendments and anything else such as like ARC guidelines or things of that nature. Additionally, the association must provide the meeting minutes, such as board meeting minutes and member meeting minutes for the past fiscal year, as well as the responsible governance policies. So these are going to be like your SB 100 policies or for example, your collection, enforcement, ADR, and those types of policies. And now, under a new law that was just recently passed, the declarant must also turn over a declarant reserve study. So this will be a study of the association and all of the required, it essentially lays out the required maintenance for the association, which may be upcoming or the current status of some of the components of the community. All
Can I
right.
ask you a question?
Yeah.
That last statement, that's about new developments, isn't it? The reserve study, because for those of us that have been around for 20 years, we're responsible for our own. Is that correct?
Right, do you want to answer that?
Yeah, so this will happen when the declarant turns over the property. So this will be for like new developments, because that typically happens within the first few years of the association being created.
That bill also, as an aside, also has, aside from the declarant reserve study, does have a requirement that management companies now have to turn over all your documents if you terminate or do not renew within 45 days. So they have to turn over documents to your association. Otherwise, there's penalties that can be imposed against them. That applies across the board. Thanks. Go.
All right, so continuing on with public disclosure. So the last thing that has to be provided are any updates to the address, agent, or management companies, and that has to be provided to owners within 90 days of any change. To get this information to owners, the declarant or association can post it on the association's website, but you have to keep in mind that you'll also need to send out this notice of the website address via first class mail or email. You must also maintain all of the information in a binder at the association's principal place of business. So for some people, this is like a policy book or just a general binder that contains all of the association's documents. The association must also mail out the disclosures to owners, but keep in mind that while the law allows you to send out notices of a website address, your governing documents might require you to send out these notices by another method. For example, some declarations require that any notices or information to owners be sent out by certified mail or something of that nature. All right, and then another method to get this information to owners is to personally deliver the disclosure. Okay, and then secondly, the second thing that associations have to do is owner education. This education has to be provided at least annually, cannot be an additional charge to owners, and should be regarding the general operations of the association or rights and responsibilities of owners in the association and its board.
How's that documented, that if that education was provided?
Sorry?
How do you document that education was provided to the owners?
Yeah.
Generally, it's done at like the annual meeting, right? And so it would be on your agenda for the annual meeting and then recorded in the meeting minutes for that meeting.
Okay.
Could it be done via like a monthly newsletter?
There's nothing that prohibits it, it just says you have to provide it. Most of the ones I've seen are provided like it's some type of, for lack of a better phrase, a class at the annual, like a session as part of the annual meeting. I don't know that I've had an association provide it via newsletter, but I can't think of a prohibition against it if you did it that way. Can you think of one?
No, I don't think so. I think I know of a couple associations that have done it by newsletter, but I think most prefer to do it by in a meeting.
Do you specifically have to earmark it as owner education? Or can you be providing your annual budget and election of officers, and this is what we did in the last year at your annual meeting? Is that enough for education?
So that's more of just an update of, that's something you would do at the annual meeting anyway, an update of kind of the general overview. The education component would be like how the reserve study works, or how the budget process works, or having an insurance agent come in and speak to the association's insurance responsibility. So something a little above and beyond just what they would glean normally from an annual meeting would cover it.
Yeah. All right, so item number 3 is going to be access to common elements. So associations are required to provide owners access to the common elements and cannot unreasonably restrict or prohibit access even during maintenance, repair, replacement, or modification of any components within or which serve those common elements. However, the association can restrict or prohibit access during such maintenance, replacement, or modification only to the extent and length of time necessary to protect everyone, such as the owners and workers, or to protect and preserve the component itself. So like closing a pool during cleaning or closing a clubhouse during construction. But as we mentioned earlier, they cannot unreasonably restrict access. So to the extent that any of that maintenance, repair, or replacement has been completed, the amenity should be opened immediately as possible. All right, however, if the common element is being closed for more than 72 hours, the association must do the following items. It must provide electronic or written notice to each owner as soon as reasonably possible. Which must contain a simple explanation of why the common element is being closed or restricted. The association must provide an estimate of how long it will be closed or restricted. So like an estimate time of the repair and then estimate reopening date as well. And then a telephone number or email address where the owners can obtain more information about closure, or ask questions, or express concerns to the board or the association in general. And the association must also provide a clearly legible notice that contains all of the information above, and that notice must be physically posted at each access point to the common element and is required to stay posted during the duration of the restriction or prohibition to the common element.
No, that's fine. We can opt, we have a pool, hot tub, we can opt to close those, however, right, for a portion of the year. Is that true? I'm not for repair, just like the
Just to
pool
close like for
obvious-
winter?
Yeah.
Yeah, but even the hot tub for winter.
Yeah, so you have to be careful, because if you start, like, let's say you can't close it down permanently.
No.
Because if you were to do that, that's going to fall under a conversion of common elements, different issue.
Yeah.
But if you're closing them for the winter, you would still you require to do the signage, because it's required regardless. And it would state like pool is closed for winter for whatever, repairs, or because it's cold out, I don't know, whatever the reasons are. Yeah, and thus far that hasn't been challenged, at least insofar as I know, for something seasonal like that. The bigger issue is, like we have an association right now because of the drought, right, who's saying, well, I don't know if we can afford to keep the pool open due to the water issue. That's gonna be a trickier one, because you're ultimately looking at it, closing it permanently, and not because it's seasonal. And so I think we're gonna have more owner challenges to that one.
Yes?
What about if for a pool, for example, if a group wants to reserve the pool for their use during normal operating hours, is it permissible to exclude everybody that's not on the pool?
Yeah, I would have the association have some type of policy that speaks about when you're able to reserve it, and, is there a first come, first serve, or how does that work? How the reserve, like who do they notify to reserve it? And then as long as you're not doing it, if you do it 5 days a week, you're gonna have a bigger problem, right? But if you're saying, like we have associations who will say you can reserve it during the week from 12 to 4 for a swim party or whatever like that. In which case you'd still post signs that say like closed from 12 to 4 for a private swim party, etc. But you'd be fine. But I would get some type of policy in place, just because you're going to have people say, well, why'd you let them reserve it and we couldn't, and we tried 4 times, Yeah.
All right, so item number 4 is gonna be pledging security for loans. So if an association is a post-Kiowa community, so that's gonna be, again, created from July 1st, 1992 to present day, then it may assign its future income, including the right to receive assessments, only to the extent that the declaration provides. So most current declarations address this directly, and some may require specific owner approval, whether that be for any loans or maybe for loans over a specific amount. Pre-Kiowa communities, so communities created July 1st, 1991 or prior, or no, I'm sorry, that would be June,
July 192,
but then we overlap.
June 30th.
June 30th, 92. Prior, those associations can still assign income under the Nonprofit Act unless the governing documents state otherwise. So some declarations might expressly prohibit, yes.
What banking institutions in northern Colorado give loans to HOAs?
That's a question that's too hard for me to answer off the top of my head, but I do have a list that I can email to you. We kind of try to keep track. And I'll see if I can find it before I leave. Otherwise, I'll try to email it. Yeah.
Because I'm sure some private banking institution is not going to look at that any way, shape, or form.
Right. There's some that specifically work with HOAs, and those will be the banks that we most frequently see, like at different events. They'll come in and because they
Got it.
specifically handle HOA business.
Yep. All right, so number 5 is going to be financial audits and reviews. So financial audit is done to ensure that financial statements and records are a fair and accurate representation of the association's finances. Audits can be done at any time pursuant to the board's discretion, but the association is required to conduct an audit if revenues and expenditures are at least $250,000 and 1/3 or more of the units requested. A financial review, which is similar to an audit in that financial records are reviewed to verify accuracy and assess financial health, but it's not an in-depth audit, just a review. All right.
I have a question.
Yes.
Does it matter whether the expenditures are coming from reserves or from operating?
I don't believe so, Amanda. No,
No.
it doesn't matter. Just 250.
Cash out.
Yeah, exactly. All right, Amanda.
Okay. Who's using secret ballots? Are you guys using secret ballots for electing directors? So one of the things that changed, I want to say it was 2022, is that you now are required to use secret ballots in contested elections. So if you have more, and I know this happens a lot because everybody wants to be on the HOA board. So if you have, 3 people running for one position, you have to do secret ballots, which is a ballot where they vote for whoever it is they're going to vote for, but they don't actually put their identifying information on the ballot, hence the secret part. Now, a lot of times, the question I get about secret ballots is, well, but we're holding these meetings via Zoom. So what happens if you hold them via Zoom? You basically have 2 options. One, there are different, so again, this is if it's a contested election. If it's not a contested election, you can do vote by acclamation via Zoom, fine, whatever, great. Whoever got the most votes wins the HOA volunteer board position. Everybody's happy. But why do we do that to ourselves? I did it too. Anyway, but if you're having it via Zoom and it's a contested election, so there are some services like HOA Now is one of them, and I'm not promoting it over any others, that's just one that's on the top of my head, that will do electronic contested election for you. You would set it up ahead of time and then people can go in and it kind of tracks like who's voting so that you don't have a duplicate vote, but also when it sends then the final tally or the ballots to the association, you don't have the identifying information, thereby preserving the secrecy. I have heard that those are a little expensive to use. My association has never done that, and our office tends to not run those because there's an entire business that does it. So it might be cost prohibitive to some of you. If it is, then your other option is to, and it gets a little squee-hod, you would still take nominations from the floor and maybe you announce ahead of time we're having a Zoom meeting and anybody who wants to go to the run for the board, let us know and we'll put their name down, right? What you would then do is you would then close out your Zoom meeting just like any other annual meeting, and then you would do the vote for the directors via mail, which is allowed under the nonprofit code. And so the way you do that is that you would mail out all of the information to owners along with a ballot, and they would mail it back with whomever they choose. The difference between a regular election, like if you're doing a mail-in ballot for an amendment, versus a secret election for a contested board position is that you have to do what's called the double envelope method, which means that you give the owners 2 envelopes when you mail everything to them. The one envelope, they put their return address on. They then stick their ballot, which has no identifying information, into the second envelope, which also has no identifying information, put it in the first envelope that has the mailing information, and send it. You, the association, get the envelope back. First envelope, you check off, oh, Amanda Ashley voted, that's great. You open the envelope and you stick that unidentifying envelope over in the pile, right? And then once you've clicked off whoever's returned so you know who's voting, then you go over to the envelopes and you count the ballots, the envelopes that don't have the identifying information on it. And that's how you would do it. There's really no other way to maintain secrecy in Zoom meetings short of those 2 options. Some people say, well, what if it's a hybrid meeting? There's still, you would have to have HOA Now or some other software allowing the people on the Zoom to vote while at the same time doing secret ballots with the people who are in person. It can be done, it's just a lot of things to keep track of. So if you have a hybrid meeting, you may want to default to just doing it by mail as well. Yes?
Could you utilize proxies?
So if it's an in-person meeting,
Or if it's a hybrid, and the people who were on Zoom sent in a proxy?
so if you had a hybrid meeting and you previously sent out all the information and then announced that, and everybody returned their proxies and people on Zoom didn't revoke their proxy because they have that option too up to the time of the meeting, so you wouldn't count them as attending because somebody has their proxy. You could then hand out the ballots again without identifying information. You, administratively, would just have to remember, like, Amanda's in person, but we can't count her on Zoom because she gave Jenny her proxy. And so now we give Jenny 2 ballots because she's voting. So yes, it can be done. Again, it's just more of an organization thing when you do these, much like every meeting, right? If you are a post-Kiowa community and your association happens to own a unit for whatever reason, that unit does not get a vote. I don't know how many of you have those associations. They're not as common, but every once in a while. If it's pre-Kiowa, then the association may or may not get a vote depending on what the governing document said. All right, ensuring common elements. If you're post-Kiowa, you have to ensure all the common elements. So if the roofs are designated as common elements because you're actually in a condo or a townhome and you're post-Kiowa, you have to insure it. If you are pre-Kiowa, you can pick and choose depending on what your declaration says. So if the declaration says you're still insuring everything, you're still insuring everything unless you amend the declaration. If on the other hand, the declaration says, or you want to amend the declaration to say owners insure their own roofs even though it's a townhome community or a condo community, you can do that in a pre-Kiowa community. Not necessarily should, right? Especially roofs, because if I'm insured and Jenny isn't, now, she causes a fire like she's wont to do. And then, you run into issues. So, all right, registering with DORA, the Department of Regulatory Agencies. Is everybody familiar with that one? So DORA, you have to register. And it includes a fee, and registration is the name of your association according to the Secretary of State, not what everybody calls it necessarily. The name of your management company if you have one, or a designated agent, and then your physical address. If you are, who all's board ran in here? Doesn't have a management company. Do we have a lot of board ran associations? Okay. So for you guys, you're not going to list a management company. You are going to list someone in your community, the board president or the secretary or whoever, and a physical address for the association. The key for you all is you have to remember that that has to be updated every year. So if the board changes and the president resigns and that was the person that was listed as your person with DORA, you're going to have to go in and update it, right? Okay, and then, good news, HB 25-1043, the House bill that passed last year that required you to have an updated collection policy as of October 1st of 2025, also imposed additional requirements for DORA registrations. So, in addition to having your collection policy that's effective October 1 of 2025, you have to, when you go to report for your DORA registration, you have to report the number of unit owners in your community who were delinquent 6 or more months in the past year. You have to report the number of owners that you sued and obtained a judgment against in the past year. If you filed any foreclosures in the past year, that has to be reported. And then any other information requested by DORA. And DORA thus far has been requesting, sometimes they request some things about documents. We've had them request how much you may have written off for owners, like if you waived interest or late fees for owners and payment plans in the last 6 months, etc. Failing to register with DORA or failing to register that information means your DORA registration is suspended. If it's suspended, then you cannot impose a lien for assessments or collect delinquent assessments. Likewise, if you do not have that policy effective October 1st with the updated requirements, you cannot collect delinquent assessments. So call me, okay? Okay. Any questions about that one? All right. And we're going to talk a little bit about the Nonprofit Act. That was Title VII, okay, of the Colorado statutes. So, special meetings. Have you guys had special meetings? Has anybody in here had the ever-pleasant recall meeting? Okay, that's good. That's good news. All right, so when you get a request for a special meeting, that provision is usually in your bylaws. Usually. Sometimes it's in your declaration. Every once in a while it's randomly in the articles. I don't know why. It should be in your bylaws, but look for it if you don't have it. What it states is that so you have your board meetings and then you have your regular owner meetings, which is usually like an annual meeting. And then you can have special meetings. Sometimes special meetings are to vote on something that you don't want to wait for the annual meeting. You're doing a declaration amendment. Sometimes a special assessment, that can be a special meeting. And sometimes it is a recall meeting. So a special meeting can either be called by the board or board president, or if 20% or more of the owners, according to Kiowa, petition for a special meeting, then the board is required to call it. Now, when they submit a petition, it has to say what it's for. And informal. If they, if you get a petition from owners or you as owners sign a petition and it, doesn't specifically state special meeting pursuant to blah, 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 the bylaws, I would not advise the association to pretend like it didn't happen, right? So it can be informal, but it still has to say why you want it. You want it to recall the board or to recall so-and-so or to vote on a special meeting. And then when the owners or the board call that special meeting, or receive that petition for the special meeting, they then have 30 days to schedule a meeting and send out notice of the meeting. Now here's the catch. The meeting does not have to occur within the 30 days. The scheduling of the meeting has to be in 30 days from the date the petition is received and reviewed, and you have to make sure that people that signed it are actually people, right? You then have 30 days to schedule the meeting, which means that if you have 30 days to pick a date for the meeting, and then you can send out notice between 10 and 50 days, then presumably you could have a meeting that's roughly 80 days from the date you received the petition. You following me on the math there? All right, well, good, because I'm not good at math, so I'm glad you're following. If you, as a board, or if you as an owner who have petitioned the board, if the board fails to set the special meeting and give notice of same, then you can call your own meeting. What you can't do is say, board, you have to do it, and then call your own meeting anyway. It would be invalid, and now we're back, and quite frankly, you're paying me to sort it out instead of using your money for whatever your association needs. When you have a special meeting, the only items or business you can discuss are what is on the agenda. So if the special meeting is for purpose of a special assessment, Brenda doesn't show up and start talking about why she's concerned over the landscaping, right? It has to be whatever that purpose is. Okay, everybody with me there? All right. And then one of the other things is changing quorum. I put this up here because this tends to be one we see a lot of where boards try to unilaterally change quorum. Or everybody wants to change quorum. The thing is, you can't change quorum without a membership vote. Quorum is almost always in the bylaws, but occasionally in the articles. And the law states, Kiowa states, that whenever there's an amendment to quorum, whether it's adding, changing, deleting quorum, that the membership has to vote on it. Even if your bylaws say quorum can be amended by the board, you cannot amend quorum by the board. Okay? You can amend other things in the bylaws. You cannot amend quorum by the board. It requires member approval to do so. Now quorum, and I think we're talking about this a little later too, but quorum, most usually in Colorado, we see quorum at a minimum of 10% up to 20% of the membership, right? So if you have 100 units, 20% would be 20 units. Some of you have quorum that's very, very high. It'll be like 50 or 60 or 70%. If you have quorum that's high, that is that high, it can be very difficult to get owners to come to meetings and actually conduct any business, right? So you might want to look at going out and kind of doing a grassroots thing with your membership to get quorum changed so you can conduct business. Yes.
Have you ever seen circumstances in the bylaws that say, for the first 25 years of your community, your quorum is this, and then after 25, it reduces to that? Is that a standard practice, and is that appropriate?
It's not a standard practice anymore. At one point, we saw more of those. Now we rarely see them, but they are there. Not just for quorum. There's other provisions that you'll see, like the first X amount of years it requires this and then it drops. So like amending the declaration, that's another one we'll see it on. Where it says you need 75% until 25 years have passed from declaring turnover, and then it drops down to 51%. I would look at it this way. If it's dropped down to 10 or 20% or low enough that you're making it, if you have a very involved community and everybody shows up and it's 40% quorum, then you have no reason to amend it necessarily. But if you're one of those communities where it's high, even at 20%, if you're in a community that can't make 20% quorum, then you might want to consider lowering it down a little bit so that you can start to get things done, right? Because the business of the association doesn't stop just because we can't make quorum. What does create an issue is people challenging whether you had authority to do what you did. Yes?
To change the quorum, is it in your bylaws of how much of the owners need to vote on that?
Yes.
Isn't it usually quite high?
Yes, depending. Some bylaws will say that it's, I've had one that said 75% of owners in the community. Well, that's hard to get. Some bylaws will say that it's 51% of quorum needed to change quorum, or a majority of quorum needed to change quorum. Well, what does that mean? If quorum's 50% and you have 51% of 50%, so roughly 26 people, let's say, you could change it. But remember that quorum fluctuates. So your minimum quorum amount might be 20%, but if you get 70 people at that meeting, quorum is now whatever that percentage is for your 70 people. So it's not always as easy to calculate as just saying it's a majority of 20%. Yes?
But it's not always a percentage of quorum, is that?
No, sometimes
it's not very common, is it?
It's more and more common now, especially as we go through amending documents. The industry standard has reverted to that, but the older documents, and I don't mean older like they were created in 1977. I'm talking older like if they're more than 10 years old, we'll see a lot of these provisions that, especially 20 years old, that'll say 75% or something like that. Now, we're going to talk about court petition process when we come to declaration amendments, but I will tell you to keep in mind that we've been successful getting some of these approved by the court for bylaw amendments when it comes to things like this. Because of owner apathy, you just couldn't get it passed. And there's requirements for that, which Jenny is going to talk to you about. Whew. Just kidding. Okay. All right, it's my 20th interview. All right, next. I know, I like that one. It's sad but true. All right, so now we're going to talk about red flags in your governing documents. I made this cute scarf from all the red flags you gave me. We won't get into those. We won't get into them, but we all know what they are. All right, tax bills on common elements. So things that might cause you concern. If you are in an association and your association is receiving a tax bill for a common element, that's probably a problem. And the reason is because common elements, the tax value of common elements is assessed to every unit as part of their tax bill. The association should not be receiving a separate tax bill for, the park. Rather, it should be split among the owners. So if you're seeing something like this, 1052 says common elements cannot be separately taxed or assessed. So what do? you first determine whether the parcel's in your community. Are they taxing you on something that's in your community? Now I say that and you kind of look at me a little funny, but that's because sometimes these things aren't transitioned properly, or a developer forgets to deed the property over, or somebody filed bankruptcy and it was purchased by someone else, and so the title history is a bit messed up. So the first step is to look and say, okay, is this parcel that we're being taxed on part of our property, or should it have been part of our property? How do you figure that out? Your declaration, usually on one of the last pages, is going to say like Exhibit A, property that's subject to this declaration, and then it'll have Exhibit B, property that can be brought in later or can be annexed in. Look there. If it's not there, look on your plat maps. You probably will have more than one plat map. You'll have your original, and then you'll have all these amendments, and if you have a big community where they've brought in additional properties throughout the years, you'll have like supplemental or amended plats for those as well. If you see it on there, great. If you don't see it on there, then it might not supposed to be part of it. It might not have been supposed to be part of your community. That was hard to get out. So, assuming it is, the next step is to look if there's past due taxes. You don't want to just randomly say, here's a check for $10,000, unless it's written out to Amanda K, that's K with the period Ashley. So, but if it wasn't, right, so if there are past due taxes, why? Is it because it was going to the developer and they didn't pay them? Was it because the association has been receiving a bill it shouldn't have been, and didn't, like, why are there past due taxes, and do we need to do something about it? And sometimes the answer is, well, we should have been paying, we the community, not we the association. Or sometimes the answer is this was never deeded over, and so the developer should have been paying and didn't. Then we want to look at deed issues. That's when we're going to get into, was it titled properly or not? If it's supposed to be titled to the association, then we need to go through that process of quit claiming it over. And then the best part, and the most time consuming usually, is to call the assessor and to get it fixed on this end. I shouldn't say it like that. It depends on the county you're in. With tax issues, I would get your legal counsel involved, because it can get messy quickly just because of the deed issues and the tax issues, and sometimes if it's a newer person at the assessor office, having to direct them to this specific section so that they don't continue to charge the association. And what they'll do is then they split out that tax bill for the common element among all the unit owners. Questions about that? Okay. All right, red flags on relationship.
I'm sorry, I do have a question. Do you expect that management group to know everything you're telling us tonight?
Absolutely, no. No, I don't.
Obviously.
So management companies, we used to have like mandatory manager licensing, and that went away, right? That was a bill that was sunset some time ago, and there was always, discussion about whether or not the legislation is going to bring it forward. Luckily, they're very focused on assessment, so we haven't had to deal with that lately. But most management companies have their own internal education system and their own internal requirements for their managers, and so they will do a lot of continuing education to keep those licenses, which is a good thing. I don't expect anybody, including Jenny, well, except for Jenny, to know everything. Because it just changes so fast, right? And so even like I do this every day-ish, 8 hours-ish a day. And it just changes so quickly it's hard to keep up on. And so to expect a manager who has tons of different properties, because there's different rules for pre and post Kiowa and residential versus commercial, so on and so forth. What I do expect, and I think what you'll find with most managers, is they will recognize if they don't know, and then they will call someone who does. And that, I think, is a good expectation. And it's the same with the board. Like, you can't expect a board, especially because you're volunteers, right? How many board members do we have in here? Yeah? Do we have any owners? Just regular, non-board member owners? Okay, boy, do you guys want to sit up here with us? I'm just kidding. Okay, and I know we have some managers. So, but board members, right? You're volunteer, you have a whole nother job. So, you shouldn't be expected to know everything, but you should be expected to know that you don't know everything and know where to find it, or at least who to call to find it. All right, let's see. Articles, declarations. So what happens if they're different names? Yes?
I'm sorry,
Oh,
before
you're
we
good.
move on, can you see on your property tax bill what portion of that is common elements for your HOA?
Generally, I have not seen them break it down like that, no. I suspect if you call them, you probably could, but I don't know. Usually, like, my tax bill doesn't break it down like that. I don't know if anybody else's does.
I've gotten on the Weld County assessors, and you go to the area and it'll highlight it and it will tell you who it belongs to, if it belongs to your association, and it will give you the tax information.
Interesting.
Yeah, you could do that, and then you'd have to probably divide it by all the, that's what you're talking about, the total amount?
It'll tell you what to do. It's public information.
Yeah, so you could look it up that way, and then you'd say, well, we have 90 units, and so
Do a
1/90th
search
would
by
be, et
map,
cetera.
And then you can select.
And the GIS maps are pretty handy for that too. All right, articles declaration containing different names. This happens a lot. If you have an association that, you know, you're the Smith Community Inc. and everybody calls you the, I don't know, table saw community, you might want to, I don't know where I come up with these, it's childhood trauma. So you might want to file like a DBA or something like that, a doing business as, if everybody in your community is referring to your community as something else. You can also do a name change, but ultimately the articles are important because that's your official name of the corporation. Now your declaration might say something different. You might say we're the such and such condo association, and then your declaration says the townhouse development. And so most of the time, if you've lived there long enough, you don't care and it makes perfect sense to you. But when it comes to title companies, or if there's an insurance claim later on, that's when it gets a little hairy. So it's hard to believe, but sometimes people screw up, except for me. So one way they can mess up is they create a corporate name that's different, or they create a corporate name that matched everything, and then when they actually go to register and file the articles of incorporation, the name's taken. And so then the name gets changed. So it can cause confusion. You can change the name entirely. The board can change the name in most cases, unless the articles prohibit you from doing so. You can do it that doing business as, which is nice because then you keep the articles and you don't have to worry about following through, but you've also given them the name that you have on, you know, whatever your bank accounts or your declaration is. Or you could do nothing and pretend it never happened and hope it's not an issue later. I don't recommend that one, but that is an option. All right, board members one-on-one meetings. This is a red flag. Why is this a red flag? Not because anybody wants in your business, but because it creates problems. So, couple things that happen. One, if you're on the board, and there's always at least one person on the board who wants to be very neighborly, and it comes from a position of well-intentioned, but they will go out and they'll say, well, I talked to Bob about the delinquent assessments or the yard or the tree or whatever, and we discussed this and everything's fine. Problem is, Bob, just like the rest of us, right? If you see a car wreck, everybody sees it from different angles. Bob's going to have a different take on the conversation. It's just by the very nature of our being human. So you should, I strongly recommend against having one-on-one meetings. If you're going to have a meeting with an owner in the community, or you're an owner in the community who wants to have a meeting, do it with the full board. Or if they've created a committee, sometimes we'll have like a litigation committee or something like that, do it with them. Because then you don't have a lot of things lost in translation. The biggest issue that this causes problems with is when you have an owner who's with legal for, I don't know, collection or covenant, for two things. One, because legal doesn't know what you've promised or not promised, either as an individual board member or as the board. And then secondly, because there's a lot of legal fees, for example, in a collection account that aren't yet posted to the ledger because the attorneys tend to bill monthly. So when you, or sometimes the manager, will say, well, sure, your balance is $500, and you've now promised that that's what they pay, and they pay $500, and then you turn around and get a bill from legal that's like another $1,000. Guess who gets to pay the $1,000? It's not the owner or legal, right? It's the association. So be very careful with these. Also, as an individual, you do not have authority to make decisions on behalf of the board. That has to be by board vote. And then, of course, there's no record of action taken if we're having private conversations. So everybody forgets to tell the manager, that's a big one, and you might not have all the information in front of you, including the balance. So what I would do instead is, if they're already in legal, I would refer them to legal, and then I would send an email to your attorney that says, we talked with this owner and we directed them to call you about whatever. And if the board discussed it, you can say the board wants to do X, Y, or Z. If it's not somebody that's with legal and it's just an owner in the community and you still have their account or their issue or whatever, then you should suggest to the owner, please email the board or the manager and request a hearing, and we will set up the meeting with you so the full board's there. Questions about this part? Okay, who uses board member proxies? Anybody? Okay, I hope you're doing it right. No, I'm just kidding. So owner proxies, owners are allowed to do proxies for meetings, period. And technically, it doesn't have to even be to another owner. It can be to anybody. You can just say proxy, here you go, and that person shows up and votes under the Nonprofit Act. However, for a board can only give a proxy, first of all, to another board member. You can't give it to just randomly to an owner or somebody else in the community. And then secondly, you can only do that if you have that provision in your bylaws. If your bylaws do not specify that board members can give proxies to other board members, then you can't do it. And so then what you're left with is that board member is either recusing themselves or they're absent from the meeting, they can't vote. If you are doing something different than that, then let's talk, because it should be.
What about, can an owner do a proxy to a tenant?
They can. They can do an owner can do a proxy to pretty much everyone, anyone. Tenants, their mother-in-law, their friend Bob. I don't know why Bob's in this association so much time, but he is. It's just the board member to board member that's the restricted one.
Okay.
Well, in regards to a renter, do they then have full ability to talk at the meeting, like the owner's meeting, if they're proxy?
So the proxy is only for voting purposes. Keep that in mind, or contrast that with, we have what's called a designated representative that you might remember from when the collection laws changed that say an owner can designate a representative. If the owner designates a representative or a power of attorney or something like that, then that person's going to be able to avail themselves of pretty much everything in the owner meeting. They can't run for the board as a designated representative unless they meet qualifications. So if your if your director qualifications say you have to be an owner in the community, then giving a designated representative or proxy doesn't count. But if it just says you have to be over 18, well, then potentially they could, because that's a little different. Okay.
So I understood that by statute, tenants cannot be at owner meetings unless they are designated as a proxy. Is that correct?
Yeah, you could say this meeting is for owners only, and if you're not an owner, you have to leave. It'll get contentious if you do that, but you can do it. If they have a proxy though, or they have something that says there's a designated representative, then you have to let them in. Now, the path of least resistance for most is to allow them in, unless you're just having an issue. Just remember, whatever you're doing, you got to apply it across the board, right? Equally, we can't say, well, we don't like, again, Bob. I don't know why he's got these terrible tenants. Keeps sending his, Bob, you're coughing, you're bringing in terrible tenants. Sorry. At any rate, so you just want to make sure you apply it equally. Sorry, Bob. I could have gone with Jim. Do we have Jims here too? All right. I'll turn it over to Jenny. I hope you're all right, Bob.
All right, I'm back. So another fun topic, aging governing documents. So what types of issues do we tend to see in aging governing documents? I'm getting the word output issue that you had.
Whoa.
All right, so legislative changes. So what is the issue with this? The issue is that the law changes, but the governing documents don't unless you take the initiative to go ahead and then change those governing documents. So the law trumps the association's governing documents, but at some point it's difficult to remember which provisions apply and which ones don't anymore. This is one of the reasons why it's so important that boards and associations keep up with the law and amend their governing documents when the law actually changes, just to provide accurate guidance to the board and to the association itself. People are often unaware of the legislative changes, so they will expect the board to enforce what is in the declaration, leading to angry calls, disputes, or allegations of the board not doing its job. But if the law states that the board can no longer enforce a provision, then the board shouldn't be enforcing that provision, regardless of what the declaration says. Similarly, the association can't enforce provisions that were deemed illegal or are no longer enforceable, or the board hasn't enforced provisions in years, like no trucks in the community. Other problematic issues with aging governing documents are provisions that aren't clear or lack detail. This is something we'll talk about a little bit more as we go through, but for example, this could be like maintenance or insurance provisions where the governing documents are very ambiguous as to responsibilities for these items. Provisions that are no longer enforceable, documents that no longer reflect today's community, and developer language. So if the community is no longer declarant controlled, but the governing documents contain a bunch of information regarding the declarant and declarant rights, this can tend to cause confusion, and it's often beneficial to remove this language. All right. Yes?
What if your governing documents say you have to have 66 2/3% in order to change any of your existing regulations in the bylaws? How do you change that to keep up with the law and also?
Yeah, I mean, that can definitely be difficult. So that's one of the issues. If the association doesn't have owner participation, then it can definitely make it more difficult. If the association really cannot get owner participation to make those changes, I mean, there's other ways to keep up with the changes, like maybe keeping a little list of provisions that are no longer enforceable. But there is something else called the court petition process that we'll talk about, which allows the association to essentially make changes to its governing documents or amend those documents through the court petition process, provided that it obtains half of whatever is required to amend. However, this process can tend to be pretty pricey, so we generally recommend it with like major amendments or amendments and restatements. So if you have that hurdle, that's definitely something that can be considered and can make it impractical for some associations. All right, so the next red flag. You've consulted an attorney 3+ times in the last year to interpret your governing documents. We're so happy you called to prevent any confusion, but that obviously indicates that there is a problem. So this can mean that your documents aren't clear, as we talked about unclear maintenance provisions, requiring the association to insure everything, or the association maintains everything but doesn't insure it. Sometimes it's cheaper to amend or clarify through resolution than to pay attorney's fees or issue a legal opinion, because those, if the governing documents are confusing for the board, they probably will be confusing for us too sometimes, and it can take a bit of time to interpret them, and the board being proactive about interpreting those and then setting a standard going forward by resolution can be extremely helpful for the association. Owners want association to enforce provisions that are no longer enforceable. As we discussed, this can become a common issue, and I'm sure a lot of you guys know the enforcement issues that have come about recently due to the new laws regarding enforcement that basically make it unrealistic for boards to enforce any type of nuisance issues. So this could be, for example, a noise issue. Owners often get really frustrated with the board for not being able to enforce these things. And while the board has a duty to enforce violations of the governing documents, it can be important to communicate to owners the limitations that are placed upon the board by the law as well. All right, your association consistently fails to meet or enforce document requirements. So documents contain old provisions that haven't been enforced in years. This can then result in a failure to enforce your own governing documents, or selectively only enforcing certain provisions, which can be problematic. Provisions that don't reflect the community as it stands today. So, for example, the nature of the community has changed, and rules and governing documents should be updated accordingly to suit the needs of the community as it currently stands. Provisions cannot be enforced because they're illegal. So provisions like, for example, prohibiting home-based businesses, or or other property protected by Colorado law. So some associations contain prohibitions against clotheslines, but retracted clotheslines are protected by Colorado law. And then the last issue would be only some of the provisions being enforced. Again, this may be a selective enforcement issue, and the association should, unless provisions are illegal, enforce provisions until they're amended out. All right.
Two again. Having trouble running that thing. Okay, there we go. Okay. Do we have any Tesla fans? The band, not the car. Signs. All right. Thank you. Thank you. We'll talk about that later. So this is something that's going to happen a lot. Your documents conflict with Colorado law because the law changes so quickly. So why am I standing up telling you it's a red flag? Because it changes so quickly. At some point, you're going to lose track of what changed. It's one thing to keep track of like signs, right? We used to say you could have political signs and they had to be up, 60 days prior to the election and then taken down. That law changed. You now have to allow flags and signs. You can regulate or impose reasonable aesthetic guidelines regarding the number, size, and location of the signs. But do you know what you can't regulate anymore?
Content.
What it says. Yeah. This has caused a big problem because people
Is that
are...
true if it's vulgar?
Uh-huh.
Okay.
Yep. If they have a sign that shows those little, I don't know, I won't even talk about it out loud, symbols, and the other guy has one that show symbols over there, you can't regulate. Now, you might be able to call the cops and say, hey, this is a problem. It's been a big issue. And the cops probably aren't going to do a lot, right? Because you have free speech. So we've had this come up a lot because we'll have somebody who doesn't have children, for example, who lives next door to somebody who does, and then they like to fly flags that might not be considered appropriate by many of their neighbors, and there's nothing the board can do about it. So why is this an issue? If you know you can't regulate content and you're the board, you're fine, generally. But the reason it's going to be a problem is that the neighbors who are all reading in the document that says you can only have political signs are not going to like it when you tell them, well, we can't enforce that provision, right? Because they don't keep up with it as much. So they're not going to know the law change necessarily. Go ahead.
So it sounds like what you're talking about is not necessarily political at all.
Right.
But you can have restrictions or whatever on commercial signs? Is there a difference?
Yeah, so you can outlaw commercial
So
signs.
it's either
So,
commercial or it's anything else?
yep.
Okay.
So you can say like, you cannot have a commercial sign except for a for sale sign in your yard, right? You can't advertise your home business. You can have a home business, that's a different issue. But you can't advertise it, or you can't have a big sign that says, you know, sign up with me for Amazon and I get a discount. But you cannot regulate content otherwise on regular signs. You can say it has to be like professionally lettered. You can say a sign has to be 2x3 and you're only allowed to display one sign and one flag, and it has to be on the right side of your yard. But if they want to fly something inappropriate on their gigantic flag, you can't do much about it. If you do not have a flag and sign policy in place, that's okay. It's not a legally required policy to have a flag and sign policy, but you are running the risk that you are going to get the one guy or the one girl or the one person who has 20 different items in their yard, all of which are variations on a theme of flags or signs. The sheer number, the creativeness of people when it comes to saying that is a flag and it's really, I don't know, a banner or a garden solar light. And you're like, no, it's, right? So you might want to have that. Again, not required, but we recommend it. Satellite dishes. Satellites are not regulated under Kiowa. It's regulated under federal law. It's the over-the-air reception devices, which is shortened to OTARD, O-T-A-R-D. And it states that you cannot prohibit satellites that are 1 meter or less in diameter. When it comes to property that an owner uses, maintains, or is for their exclusive use. So if you're in a condo association, you have to allow a satellite on the patio. You don't have to allow them to like mount it to the post. You can say they have to have like some people put the board across the corner and mount it there. What you can't do though is you can't prohibit the satellites that fall within that size range under federal law, and you have to You cannot impose restrictions that would unreasonably delay or hinder or increase the cost or decrease the signal, so on and so forth. Budget veto, yep.
Can you regulate the height that satellite or antennas can be?
Yes, as long as it, well, first of all, if it falls within that 1 meter range in diameter, then you're really restricted as to what you can regulate. But let's say it's just a general 5-foot TV antenna that's well outside whatever the federal requirement for antenna is. You could say, no, you have to have an antenna within this range and it has to be here and here, as long as you don't block the signal. Again, a little more flexibility if it's outside those size limitations, but not a lot. Okay, budget veto process. Go ahead. Did you have a question?
What about solar panels? It's not on here, but
Yep, so solar panels, they don't fall under federal law, they fall under Kiowa, and they are, you have to allow solar panels on property that the owner owns or maintains. So if you're in like a townhouse or a condo community and the association maintains the roofs, you would not be required to allow solar panels. But if the owner owns it, if you're a townhouse and the owner does their own roof or whatever, single family homes, you have to allow it. You can impose some restrictions, but they cannot increase the cost by more than 10%. They cannot delay the installation, and they can't decrease the efficiency of the solar panels. So you can't say like you have to put them on the back of the house if there's no sun on the back of the house, right?
Can I ask a follow-up on that? So we're in an area where we have some acreage and people want to do a solar panel freestanding, and we've regulated against that. Is that legal under this?
It depends. I know everybody's favorite answer. So yes, in general, you can determine like location and things like that as long as you didn't increase or decrease by that 10%. So if the owner comes to you and says, this is literally the only place we can put it where we get this energy efficiency, then you have to allow it. Side note, there's a bill pending in the legislation right now that talks about portable solar energy devices. It's making its way through. It's anticipated to pass. So those would be the kind that you could like plug in into your porch, or the kind that you see camping where they're running generators off the solar panels. If those pass, the bill as written today has a little bit about also imposing reasonable aesthetic guidelines and restrictions, but you would have to allow them. All right, budget veto process. Some of you have no idea what this is. It's okay, I didn't either at first. So the budget veto process, Kiowa, in Title 38 says that some of your declarations require approval, right? You say if you're going to increase the budget, the owners have to come forth and approve it. Under Kiowa, you can do what's called, what the law says is that Kiowa says that a budget, a proposed budget, so the board proposes a budget, it is going to be deemed to be approved unless a majority of owners veto it. So instead of having to have 67% of owners vote to approve a budget, it says the budget passes unless 51% of all the owners come and veto it, unless your declaration says otherwise. So if your declaration still has those provisions that require approval, you can't use the Kiowa budget process. If they don't, it defaults to the Kiowa budget process. And certainly you can amend the declaration to switch over to the budget process. Sometimes we'll do a hybrid, like well, you say if it goes up to a certain amount, it can be vetoed, and then past that cap, like past 5%, then you have to vote to approve it. This doesn't apply if you're like a limited expense community or commercial, you would have to use it, things like that. Zero-scaping, that's a big one that passed. Go ahead.
Quick question. So what we've done on our budget meeting is it's part of our annual meeting, and our annual meeting has a quorum of 29 or more members. Let's say 40 show up out of 276. Then the budget veto could be just 20 of those people present, right?
No, the budget would.
21, or, I mean, 51% of those that are present?
No, it's 51% of all owners in the community.
Oh.
Now, you may want to have your budget meeting before your annual meeting, because if you have your budget as part of your annual meeting, you have to make quorum to do anything.
Right.
But Kiowa says when it comes to the budget process, quorum notwithstanding, you have to have a majority vote to veto it. So if you do your budget meeting like the hour before your annual meeting, it doesn't matter if you make quorum, it matters if a majority show up to veto it. Yep.
So that only applies, that budget veto process only applies to post-Kiowa communities, correct? Or does it apply to pre and post?
It applies to both unless the declaration states otherwise.
Okay, okay.
All right, xeriscaping, that was a big thing. It's still a big thing because of the drought. Xeriscaping law was passed in 2023. It says that you cannot, for detached family homes, you cannot prohibit xeriscape, non-vegetated turf grass, or drought-tolerant grass. And not only that, but you as the association have to adopt at least 3 pre-approved water-wise designs and post them on your website. You also cannot enforce more than 20% of hardscape, etc. We've talked about secret ballots. We talked about notice requirements. Some of your documents will say like 10 to 60 days for owner meetings. It's 10 to 50 days. So if your document says that you can give owners more than 50 days or less than 10 days, please do not do that. It's 10 to 50 days regardless. And then a lot of times in the bylaws, there'll just be provisions that should be elsewhere that they're hard to find because they shouldn't be in there. Or some of you have recorded your bylaws. Bylaws don't get recorded. Some of you have included all of your policies in the bylaws. It's not a good idea because the policies change frequently, but if you've put them into your bylaws, you now have to amend your bylaws to change the policy. And the board can only amend certain parts of the bylaws, which means that your membership is going to have to vote every time you want to change them. All right. And then, huh? Sure. Sorry. Do you see me blindly looking? Like, where is she?
Our, one of the HOAs has bylaws, but they've never been able to find an executed copy of them. So does the current board have the ability to revise those bylaws, and does that have to be approved by the membership? But the bylaws that we currently have I've never been able to find an executed copy.
Yeah, so basically what they would be looking at doing is just amending and restating the bylaws, which is going to require a member vote. If they were only doing certain things, like not quorum, not board qualifications, etc., the board could do it on its own.
If they were just to approve the existing ones, can they do that?
Unless they're doing something with quorum, etc., but they'd probably be fine with it. Okay. Declarations. Issues, red flags with declarations. Some of you aren't doing this. You have, it'll say your annual meeting has to be a certain time of the year. I've had this argument recently. It was probably with some of the people in here. They said, wait, what? What do you mean we've always had the annual meeting in September. It's like, well, that's okay, but your bylaws require you to have it in February. Now, is this a problem in general? No, until you get to court on something else, and then the defendant's attorney goes, but they didn't do this, 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 or this. And 5 years ago, even 3 years ago, the court used to say, well, that doesn't matter because we're here talking about this other issue. But now the courts tend to go, well, if you didn't do that, what else haven't you done? Because you're not in compliance, right? So the declaration caps on assessments. Maybe you don't want those, maybe you don't use those, maybe your insurance is too high and you can't deal with the cap on assessments. The supplemental assessments, if you don't have provisions in your bylaws about supplemental assessments, like if my roof was the only one that needed repaired and you want to charge that back to me because I, much like Jenny, burned a hole in it, and the neighbors shouldn't have to pay for it, you have to have authority in your governing documents under an individual purpose assessment in order to do that. So it doesn't give you a lot of flexibility. Loan limitations, Jenny spoke to those earlier, you can't borrow or you can't pledge. Special assessment authority, if you don't have special assessment authority in your declaration, you cannot assess a special assessment regardless of whether it's approved by owners. So these are all things that you might want to take a look at because they're red flags for 2 reasons. One, because they're really kind of tying your hands as an association. Most often because of the insurance costs that are coming through is where we've seen it the most. And then also just because there's no flexibility whatsoever, right? They're red flags because you're probably not doing them. And then bylaws, annual meetings, that's that one I mentioned earlier. Quorum, that can be a hang up. Unanimous approval for any board action taken by email. Do some of you have that old provision in there? Old, it's like 10 years old. So the nonprofit code says that you can adjust that provision so you no longer have to have everybody agree to take consent via email on the board. You can do action without meeting, which is action via email. But if you have that requires unanimous consent and you don't get it, it doesn't pass. So that can be amended as well. Okay, and then the last thing I'm going to talk about, at least temporarily, is governing documents that are in conflict from one another. And this is, I mean, we've gone over it a little bit, so I'll be quick on this one, but One example that we see frequently, the articles say the board's supposed to be 3 people and the bylaws say the board's supposed to be 5 people and they're in conflict. Now, most of the documents will have what's called a conflict provision where it'll say if the documents are in conflict, the declaration trumps the other ones, right? But if they don't, this is this very faded graphic up here tells you kind of the order things go. So your declaration is going to trump the articles, that'll trump the bylaws, that'll trump the rules, guidelines, and policies. The exception being if the law changes, then these change, right? Because they're more flexible, so they won't be in conflict with the law, but they will be in conflict with the other governing documents. If this is happening to you, again, there's no requirement that you amend the documents. What the requirement is that you follow the law. So just remember that it's one thing to follow 1 or 2 changes. It's another when you have like 20 provisions that you can't remember because they change quickly.
Can I ask one question? Unfortunately, we're a pre-Kiowa community, and our documents say that we are not allowed to do special assessments. So that means that we would have to increase our monthly assessment for a certain amount of time. But then you're not going to be able to put a claim in on your loss assessment clause on your insurance. Is that common? How do you handle that?
It's common in the older documents. What I would recommend is that you do a limited amendment to the document, to the declaration, and add in special assessment authority.
Okay.
And when you go out to talk to your owners, because you want to talk to your owners before you pay the attorneys to do this, or you're wasting money, right? Because if they're not going to pass it, why are you paying me to do it? You know what I mean? I mean, I'm fine with that, but you know what I mean? So what you want to do is you want to go out and talk to the owners and say, listen, if we do this, yes, it gives the board special authority, and we can put caps on it if we need to, as to how much the board can assess. It still has to be approved, but if we do it this way, then you're more likely to have your insurance cover it with a loss assessment.
Okay.
All right, next red flag. Governing documents are silent on important issues. So one of the common ones are no or very little maintenance and insurance provisions. The declaration should always very clearly outline maintenance and insurance provisions in the declaration to clearly delineate the responsibilities of each party, being the association and its owners. If this information is unclear, either party, if the information is unclear, either party may be paying for something that it's not necessarily responsible for, or again, the association might have to seek a legal opinion for clarification. Number 2, no authority for individual purpose assessments. So these are generally assessments that are charged back to owners in the event that the association performs maintenance to one specific unit, or owners may cause damage to the common elements, which the association wants to then charge back to that owner. If the association does not have a provision addressing these, then the association cannot levy these costs back to owners, and we would definitely recommend amending the declaration to include this language. Number 3, no amendment provisions. So this can be totally problematic because it causes confusion. In the event that the association wanted to amend its declaration, it doesn't have clear guidance with respect to what kind of approval it would need in order to amend the declaration. Now it could use the provisions of Kiowa as a backup, but it's helpful to have this information contained in the declaration itself. No proxy information and no director proxy information. These should be addressed for all of the reasons that Amanda already discussed earlier. All right, number 2, ambiguous definitions of terms. Yes?
If your documents don't have an amendment provision, how do you put one in? Do you just go through the process of having the membership vote?
Yeah, default to the 67% under Kiowa, and you'd amend it to put it in. But when you do amend it, you could put it in at 67% or down to 51%.
Yes.
For future amendments.
All right, so ambiguous definitions of terms that make enforcement difficult. So this might be commercial vehicle. Like, what exactly is defined as a commercial vehicle within the community? If the association doesn't have a clear definition, then it makes it really difficult to enforce this provision. What do you mean by screened from view? So sometimes associations will say, yes, you can have, solar panels? What's a
Trash
good
cans.
Trash cans, but they should be screened from view. So what does this mean? They have to be covered by an item that makes them not visible to someone? And does that mean from another lot or from the common elements, or what necessarily constitutes an item being screened from view?
We had somebody that, I don't know if it was one of you guys, but they wrapped camo wallpaper around their trash can.
It's invisible.
Is it? I'm not kidding, like it was screened from view.
They should have just put a picture of John Cena on there. All right, next, what does an exterior surface mean? So is this like the yard, ground, or is this the siding of the home? What constitutes an exterior surface? And this is often used in, for example, condo communities where an owner wants to install an antenna or something, or a satellite dish, but the governing documents say none of these items shall be installed on the exterior surface of the condominium building. So it's important to set clear definitions for these things. And then maintenance and insurance provision. So sometimes it'll say owner maintains the unit, but then doesn't really specify exactly what constitutes the unit and the boundaries and to the extent of the owner's maintenance responsibility. So these are really important things to include to avoid confusion. And if you're in a condo community, I know a lot of us have dealt with water leaks, so that's another common issue that can come up, and a lot of confusion can be caused by just ambiguity with respect to maintenance and insurance provisions. Yes.
So Melissa Garcia helped us do a maintenance matrix that
She's dead to
identified
us.
insurability. Huh?
She's dead to us. She retired, so now
Yes,
she's dead to
yes, I
us.
know that, but she helped us.
Yeah, she's kidding.
In 2015. actually.
Okay.
So, but one of the questions that always comes up is whose responsibility is it to maintain limited common element, like driveways, etc. And we've had many discussions, despite the fact that it's pretty clear, you know, that some say, well, you have to look at the plat to decide that, you have to look at your maintenance matrix. What is the final rule on limited common element? Who's responsible for maintenance?
Yeah, it depends.
It does, it depends on what your declaration says. So most of the time, in a perfect world, it will say limited common elements, which are defined as common elements adjacent to the unit, are the owner's responsibility, right? However, there's still some subtle nuances to that. Like if it's a condo community and it's a structural issue, then you might have an argument there. But that's the language we're looking for. We're looking for limited common element adjacent to are going to be the owner's responsibility. If you don't have that language in there, then either you're going to fight it out or it's going to default in the owner's mind to the association's responsibility.
And it really depends on the language too. Like some declarations will say that the owner is responsible for just keeping them neat and free and clear of like personal items or something like that, but the actual maintenance and repair responsibility might still default to the association. Just depends on the documents.
So if Melissa looked at our documents and said driveways, concrete driveways are limited common element and they are the owner's responsibility. That's pretty clear, that's pretty down the cut. I mean, we can't have them say, well, but it's part of the common elements and.
No, and you'll have that. You'll have owners who say, but it says common element and the declaration says common elements are the association's responsibility, which is true. But what a limited common element is a common element that is only for the personal exclusive use of less than all owners. So what she probably did is she probably looked at the plat map, which will often designate with the initials LCE or CE to determine limited common versus common. Then your declaration will have definitions of what those are, and that's where you'll find that adjacent. But if you have a legal opinion, I don't know how she wrote it to you. And Melissa is wonderful. She's not really dead to me. I'm just mad at her because I don't work with her anymore. So, because she left me here by myself. No offense, Jenny. Anyway, but if she issued something like that, she would have based it on that
Okay.
language or what she saw in your declaration. That doesn't mean an owner's not gonna try to argue it.
Sure.
It doesn't mean you can't look at amending it to make it even more clear, although if I don't wanna pay for it, that's probably not gonna help me, right? I'm still gonna argue I shouldn't have to pay for it, but yeah, if it's limited common elements are generally, unless the declaration says otherwise, going to be that unit owner's responsibility.
Yeah, and I mean, our, like, maintenance and opinions matrix are essentially our opinion of responsibilities with respect to maintenance and insurance within the community. So I'm sure, Melissa did an in-depth review and then
She
provided a
did.
comprehensive, yeah.
She was excellent.
Yep,
Yeah,
that's
she
how we
is.
always do it. All right, next slide. All right,
What you're
so,
gonna do as good a job.
What?
The two of you as a team are gonna do as good a job.
She
Of
keeps
course.
sending pictures of her feet on the beach, that's all
it's
I'm
really
saying.
annoying. Yeah.
Oh, that is so painful.
I know.
Yeah, she's really living life. It sucks for us. All right. Documents don't limit personal liability or indemnify the directors. So the Colorado Revised Nonprofit Act allows associations to eliminate or limit the personal liability of a director to the association or its members for monetary damages or a breach of fiduciary duty as a director. But in order to take advantage of this, the language has to be contained in the governing documents. So if that is not contained in the governing documents, we would definitely recommend amending the same to include it to protect yourselves as board members. All right. Next slide, another red flag.
Hang on.
All right.
Okay, sorry.
No
I
problem.
got distracted.
Documents don't allow assigning future incomes for loans. So we already briefly discussed this with respect to approval and the potential benefits of doing so. But given the increased cost of insurance and high rate of insurance deductibles, many associations have been forced to take out bank loans to pay for various maintenance and repairs. So this is often done for like large roofing projects within communities or things of that nature. As security for loans, banks demand assignments of associations' future income, being assessments that it will receive in the future from its owners. However, if your association is a post-Kiowa community, meaning it was created July 1st, 1992 or after, you must have specific authority to assign your income stream in the declaration, or your community cannot lawfully take advantage of this and provide security for a loan and in turn take out a loan. All right. Gaps in or obsolete provisions. So this kind of goes in hand with the ambiguous provisions slide. So for example, short-term rentals. A lot of associations' declarations may prohibit short-term rentals, or they'll want to prohibit short-term rentals, but what again constitutes a short-term rental? Like, is this 6 months or is it 30 days? What is the association trying to prohibit? The next one is smoking or marijuana. Is smoking allowed on the common elements, limited common elements within the unit? Does this include marijuana? What other kinds of requirements or restrictions are imposed against these activities within the community? And some declarations generally contain like nuisance provisions, and while one owner might consider smoking a nuisance, it's better to have specific language to have for the board to have something to point to. Yes.
Are we allowed to restrict anything within a unit other than an illegal thing? But I mean, can we say you can't smoke in your unit?
Only within the declaration. So any use restrictions, any use restrictions have to be contained in the declaration. So if it's not already contained in the declaration, this would have to be done by a membership vote.
You can do like a completely non-smoking community, for example.
Yeah.
We have communities that do no rentals whatsoever.
Right. Oh, okay.
Yeah. Although obviously, like, depending on the type of community you have, this may be difficult because owners may want to smoke within their units.
Yeah.
So if people are not willing to vote in favor of the amendment, then ultimately it won't pass. Exactly. All right, maintenance provisions that don't reflect the practice. So I don't know about you, I so often hear, oh, well, the declaration says that owners are responsible for maintaining this, but historically the association has done it. Well, I mean, that's problematic within itself, you know, because the association now is expending association funds for something that it's not responsible for. So either the amendment, the declaration should be amended to reflect the current practice, or the association should push that responsibility back onto the owners, for example, if that's the case, to ensure that the association and its owners are complying with the governing documents. All right, and then declarant rights. So do they still exist, and are they in the declaration when they no longer apply? If they're in the declaration when they no longer apply, we generally recommend removing these, as we spoke about briefly earlier, just to avoid confusion and to ensure that the governing documents reflect the current state of the community and provide accurate guidance to the board and future boards as well.
What would be an example of that?
So a lot of times declarations will discuss like declarant rights or annexation where, for example, the community has been created for a very long time and annexation is no longer relevant and all of the property has already been annexed into the community, but now the declaration is like a 80-page document because it has all of this information that's no longer relevant. Yeah. Do you have any other reason that declarant rights should be removed?
They'll have, you know, some of the documents, even though the declarant turnover was years ago, will still require declarant approval of amendments. That would be something you'd want to amend out because it's really difficult to find a declarant from 30 years ago. Sometimes it'll say, while the declarant provision is in there, that they have to obtain permission from like the city or something like that. So we would want to amend all that out. I wouldn't advise to amend. Like, you don't want to amend your documents just to remove those provisions, but I would, while you're amending your documents, go ahead and also remove those provisions.
All right. Another red flag, the original documents were created by previous board and not legal counsel. So this is pretty straightforward, but it has been our experience that most attempts by board to save on legal fees by preparing their own documents essentially end up falling short in terms of what's required, and in the long run end up requiring much more extensive legal review and result in higher legal fees because we will have to essentially just do a much more in-depth review, and that takes more time and will require changes in excess of those which we would essentially require if we were to prepare those documents ourselves. So we always recommend consulting legal prior to making changes and not knowing necessarily if those changes are correct. Yes?
It seems to me that probably a majority of HOAs, because of budget restrictions, attempt a DIY document review. And it is so problematic because they don't know Kiowa, they don't know law, they don't know anything, and then they try and create these documents. And why do people do that? Just saving money? Is that what it's all about?
It saves money. It does save money initially. When it doesn't save money it's like speeding, right? I know I've used this example multiple times in here, but speeding, if I'm speeding, I get there faster. And I'm speeding every day. And then one day I get pulled over. And now I not only don't get there on time, but I also have a huge fine. And that's how these documents are. So you could amend these documents and you could not have a problem until there's a problem. But when you do have that problem, it's a big one because then you get drawn into court and now you're paying to fix the documents, you're paying to defend the documents, and if you lose, you're paying the other side's attorney fees, which ends up costing, and I'm not kidding, significantly more than it would have for the fixed fee to do the document, whatever the document was to begin with.
Did you use the speeding analogy just to hurt me?
No, Jenny, I haven't told anybody you got pulled over for speeding.
All right, so next slide. All right, another great meme. If you guys continue to come to these classes, you will notice that Amanda, who prepares these PowerPoints, initially picks some truly amazing memes.
That was nice of you to say. Thank you. It's unexpected.
Yeah, I guess so. All right, so Quorum requirements causing issues. Quorum requirements being too high and owner apathy is real. So we see a lot of communities with quorum requirements that are like 50%. And this is extremely high, especially if you're in a community where you don't typically get high owner engagement. And so quorum can definitely be decreased. However, if you're in a community who, are they FHA loans?
FHA and VA, yep.
If owners are using FHA and VA loans to purchase units within the community, I believe you have to have at least a 20% quorum requirement in order to be eligible for these types of loans. So that's definitely something to consider, because while nothing prohibits you from lowering your quorum below 20%, that is something that could make it a little bit more difficult to get approved for these types of loans. Yes?
When you talk about no quorum, no business, is that only applicable during the annual meetings?
Any meeting where a quorum is required or business is being conducted, which requires a quorum to be present.
Okay, if it's just a board meeting, then it's just the quorum of the board.
Yes. Yeah, some documents have a different quorum for the board than it does for the members. Yes.
What loans are those again? FHA and what?
VA.
VA.
Yes. All right. And then yes, like one of our wonderful guests mentioned, no quorum, no business. So if you cannot obtain a quorum, then no business of the association can be done. So if your governing documents contain a 50% quorum, it's something to consider for the association to maybe want to amend their documents to lower these requirements to ensure that quorum is attainable and the association can continue doing its business. All right, Amanda's turn.
Well, Bob, I'm glad you're back. First of all, I thought I offended you, and secondly, it's time for this slide. All right, so things to fix. Certainly you can stick your head in the sand. It's not a problem until it's a problem, much like Jenny's speeding earlier today. But here's some ideas if you want to move forward. So amending the articles. If you need to amend the articles, the board can actually approve a lot of the article amendments under 7130-102, which is the nonprofit code. And then owner approval. So again, if your articles require owner approval, then you have to go with owner approval. But some of the things the board can amend on its own is when it comes to things like the registered agent, which is the person that receives all of your legal notices in the event that you are sued, if the association is sued, so you want to keep that up to date. The board can delete names and addresses in the articles of the original incorporators or directors. They can delete the original registered agent and update it as long as they filed what are called statements of change with the Secretary of State. They can change or delete the principal office. So if it's an old one that was when the developer first created the community, they can update that. And then they can maybe extend the duration of the nonprofit corporation, again, depending on the article provision for your specific association. They can also change the name if they're substituting words. So if they're substituting corporation or incorporated or company or limited or something like that, the board can do that of its own authority unless there's a provision in the articles preventing them from doing it otherwise. Any other changes outside of those, including if your articles require all changes, must be approved by the owners, right? So these are the ones the board can do on their own, absent a provision restricting it in the articles, and then otherwise it requires a membership vote. If your articles do not set forth a requirement to amend them, then the default is that a majority of at least a quorum of owners is required. So 51% of quorum. Now remember that quorum, if your quorum is 20% and you only have 20% of owners showing up at the meeting, then a majority of that quorum is 51% of 20%. But if your minimum quorum is 20% and you get 50% of owners showing up to your meeting, you've met quorum and exceeded it. So now to amend the articles, you would need a majority of that 51% or 50%. So it just depends on the number you end up getting there. Amending the bylaws, we've gone over this a couple times, so this is just a reminder. Pre-Kiowa, you can amend darn near everything on your own except for quorum. Post-Kiowa, there's only certain things the board can amend on its own, absent a provision requiring otherwise in the bylaws. So if your bylaws say that the membership approval required for every amendment, then that's what you have to do. Let's see. Bylaws, the default is a majority of quorum usually to, if they don't have anything else in there regarding amendment. Yep.
You know, you keep saying you can amend it. Is it pricey to amend either the bylaws or the resolution?
The articles and the bylaws aren't overly pricey. I want to say it's like, so based on what I know of the other law firms, we kind of tend to be in the same range depending on what's included. So articles, for example, are usually like $700 to amend them. Bylaws are more, I want to say they're between $1,400 and $1,700. The declaration's the big one because that's the most work. It's the largest one. It's the most complex. It requires the most time, and it requires the most back and forth with the board to decide what wants. So that's when we get into more of the thousands instead of the hundreds.
But also that's for a full amendment and restatement. Like if you're just seeking to amend one provision, then that you would do a limited amendment, and that can tend to be a little bit cheaper.
Oh, okay.
Yeah, like if you're just doing a board member qualification, or board member qualifications, then usually you're looking at less than $500. Yep.
What if you're trying to change the date for the annual meeting, but you can't get a quorum of the owners? And then later, somebody brings that small little thing up in some legal avenue. You were limited, you wanted to do it, but you couldn't do it. If you have documentation of that, would it protect you from anybody bringing that fact up?
It helps, yes. So we see this like special assessments. Let's say you have to have 67% approve a special assessment, and in order to fix the roof, you have to do a special assessment because you don't have money. And so you call a meeting, nobody shows up, you don't have 67%. You call a second meeting, nobody shows up. So then you send out, I would send out like communications that say this is why we have to have that. I would have an informational meeting, even if they don't show up, showing if somebody sues later, and they will, saying you didn't maintain this. You can't just say, well, we didn't have money. What you have to be able to show is we tried to do all these things. We tried to act in our fiduciary duty to the association, but the membership would not approve it. So that way the board is protected, showing it has taken those actions even though the membership did not approve the overall issue. Yep.
So is there a rule of thumb for a reserve?
For how much you need in the reserve?
Correct.
So not generally. What Colorado does not, so here's the fun thing. Well, okay, it's not really fun, it's law fun. Yeah. Is Colorado requires you to have a reserve study and an investment of reserve policy, a reserve study policy, and an investment of reserve policy, but it does not mandate a reserve study. So you could do it every 3 years, 5 years, the board can do it on its own. And then the reserve account, we do not have a mandatory funding requirement in reserve account. There's states around us that do. California has a mandatory reserve amount that they have. We had a bill a couple of years ago that we thought was going to pass through that the governor vetoed that would have required mandatory reserves. So the best thing to do is to contact a reserve study company, and they will give you an overall idea of what you need in your account, in your reserve fund, in order to replace every component as it starts to deteriorate over the life of the component. If you can get 100%, that's fantastic, but I think most associations are on the very low end of like the 20 to 30%, and that's not a rule of thumb, that's just because it's just tough to get assessments increased, especially when, you know, we're paying. I took out a 401k for gas to get up here, so yeah. All right. You didn't hear that from me. Okay.
That one by fast, I'm back. All right, so amending the declaration. So this requires owner approval, which cannot be less than a majority of owners being 51% or no more than 67%. Although there are a few exceptions to this, which would be that the association cannot create or increase special declarant rights, increase the number of units, change the number of boundaries or allocated interests of a unit without the vote or agreement of owners of at least 67% of the units, or more if the declaration specifies more. So generally, if a declaration's general amendment provision says that the declaration requires 75% to amend, then this would automatically be lowered to 67% unless it's one of these specific categories. But these are definitely not everyday amendments. So next, process for owner approval. So this can either be done at a meeting or through a mail vote. With respect to meetings, the notice for a meeting would have to be given, as Amanda said, not less than 10, but no more than 50 days in advance of the meeting. And the notice should be provided by mail. The notice should also be posted in a physical place within the community, and the law specifically states that the place where it's posted should be a conspicuous place. It should also state the date and time of the meeting and the items that will be on the agenda for the meeting. Votes for amendment may also be conducted by mail. So if a vote is conducted by a written ballot, the ballot should state each proposed action, provide an opportunity for owners to vote in favor of or against that proposed action, and any ballot must also be accompanied by a solicitation letter, so solicitation for that owner's vote. And the solicitation letter should generally state the number of responses needed to meet quorum, percentage of approvals necessary to approve each matter, except for elections of directors. It should also state the time by which the ballot must be received back by the association, as well as be accompanied by written information sufficient for owners to reach an informed decision on the matter that they're voting on. All right, and then with respect to mortgagee approval, so the association must send notice of the amendment by certified mail to each mortgagee, attach a copy of the proposed amendment itself, and then post it in the county newspaper 2 times at least 2 weeks apart. If there's no objection in 60 days, then it's deemed a yes, or approval of the amendment. So this is a little bit different from owner voting, because with respect to owner approval of amendments, the owner actually has to respond with their ballot or their vote stating that they approve the matter. However, with respect to mortgagee voting, if they don't respond, they're considered to approve the amendment. So it makes it a little bit easier.
How
Yes.
does the board know if there's a mortgagee? Because most homeowners are not going to communicate that to their HOA board.
Yeah, Amanda.
Well, so
I'll let her take that.
what we do is at some point in the amendment, sometimes you want to wait to see if the amendment is approved by owners before we go out and get mortgagee approval, purely for cost. But if you're sure the amendment's going to pass by owners, we can do them at the same time. Anyway, what we do is we're going to go to the board and we're going to say we need a list of all of your owner names and addresses in your community, physical addresses, not their mailing addresses. We then order what are called O&E reports, which are ownership and encumbrance reports, which is going to list whether or not there are lien holders filed on the property. And then the attorney's office will send out, they publish in the newspaper and then send out notice to those the properties that have mortgage, to those mortgagees, those security interests. And then you wait 60 days to see if they respond, which they don't, knock on wood, I've never had one, and then it's deemed to be approved.
This is way over my head. Is this virtually any amendment or just something very limited?
It honestly depends on the community. Like some communities require this for any amendment, but some require it for material amendments. So sometimes it's like change to boundaries or use restrictions or insurance or maintenance, or sometimes it'll also say anything affecting the mortgagee's rights.
It will be in the declaration provision.
Yes.
Declaration will
Yep.
say whether we even have to do this.
Yep,
Yes.
it'll say under your amendment provisions, it'll talk about owners, it'll talk about whether you have to do declarant or FHA or VA, it'll talk about mortgage approval. Now, sometimes it'll just say mortgage approval, and sometimes it'll say eligible mortgage approval. If it says eligible mortgage approval and that term is capitalized, there should be a definition, and it will say something to the effect of these are mortgages who have written to the association saying we want notice, which means we don't have to send it to any mortgage unless they have written to you.
Okay.
And then we only send it to them. So that makes it a lot cheaper. Okay.
You beat me to the punch, that was next.
Oh, I'm sorry.
All right, yeah, eligible mortgagees make it a lot easier, because like Amanda said, nobody really does that, so then there's no need to go through this process.
Charged your mellow.
But that can also be covered by the posting in the county newspaper, because that's public notice to everyone. So although I'm sure most mortgage companies are not looking through that and will not respond because of a posting that's in the county newspaper, it's another method to satisfy this requirement. All right, and then like we said, this is all contained in the declaration, so the declaration might prescribe an easier process than the one that we've outlined. It all is document specific. Okay, continued. So the court petition process, this is intensive. So the court petition process allows the association an alternate method to amend its declaration in the event that it's not able to obtain owner approval. So, to qualify for this process, the association must obtain approval from owners representing at least half of what the declaration requires. So if, for example, your declaration requires 67%, then this is 33.5%. No mortgagee approval is required to commence the court petition process. However, prior to filing the petition, an association must send at least 2 written notices to owners advising them of the amendment, hold at least 1 membership meeting to answer questions about the amendment, and conduct the vote of owners and obtain approval from owners representing at least 1/2 of what the declaration requires. All right, and then part 2 of amending the declaration in the court petition process. So assuming that all 3 of those things have done, the notice to owners, sending at least 2 written notices, holding 1 membership meeting, and then conducting a vote and obtaining half of the membership approval requirement, the court petition process can be started by the association's legal counsel. However, it's important to be aware of the statutory deal breakers, which would prohibit a judge from approving a proposed declaration amendment by the court petition process. So in the event that 1/3 or more of owners file objections with the court, 1/3 or more of first mortgagees file objections with the court, or the proposed amendment changes allocated interests, meaning the number of votes allocated to each unit, a unit's share of assessments, or a unit's interest in common elements, or the proposed amendment seeks to terminate the community, then the association cannot utilize the court petition process, and the court cannot approve the association's amendment without owner approval. These items would have to be approved by owners themselves. The court petition process is a good tool to address homeowner apathy, so when owners are not responsive, but it may not be as useful in situations where owners have strong objections to the proposed amendment, or when a faction of owners strongly oppose the declaration amendment. It's feasible that owners will convince 1/3 or more of the members to file objections with the court, in which case the judge could not approve the amendment. And so, like we talked about, it's really important for the board to essentially feel out its association. If the association has, or if the board knows that a large chunk of owners are really opposed to whatever it's trying to amend in its governing documents, it may not be smart to, 1, go through with the amendment or to initiate the court petition process, because amendments and the court petition process can both be extremely expensive. I mean, and they can also be very time intensive. Like if the association elects to go through the court petition process in order to pass an amendment and restatement, so a comprehensive reconstruction of its governing documents, this process can sometimes take 15 months or more. So it's important for the board to ensure that it has the backing of its owners and is really understanding what it's getting into with this. All right.
Okay. Well, you guys are getting so close to the end. Good job. All right, so when it comes to amending rules, guidelines, policies, regulations, procedures, architectural guidelines, it's a little bit of a simpler process generally. Some of you, your declarations will require owners to vote on certain changes, but most of the time the board has authority to implement rules and regulations for the community or for the common elements. It has authority to do architectural guidelines. Some of your documents will give that authority to the board. Some of your documents will say that it is the architectural committee that implements or makes the guidelines. So watch for that language. When we come to these types of things, so your good governance policies and policies in general, the good governance policies are required under the law, the 9 of them. When it comes to policies in general, and then particularly rules, regulations, and guidelines, the court will look at rules and regulations and the guidelines with stricter scrutiny because they're looking to see whether those rules are completely arbitrary and capricious or whether they are meant to further the goals, the ideals, the whatevers of your community. So if you have a rule that says you have to park diagonally on your driveway, that's probably not going to fly with the court because there's not really a basis for it. On the other hand, if you have a rule that says you can't paint your house lime green and we have a palette of colors, that one probably would go, assuming it's not like diamond encrusted or something like that. Oh, wrong way, Amanda. Okay, this is my favorite cartoon. It says the Homeowners Association wants me to stop leaving my worries on the doorstep. All right, and then briefly, limited amendments. We did discuss this a little bit. They are less expensive. They tend to be quicker. They are great if you only want to amend 1 or 2 provisions at a time. For example, a lot of you are interested in allowing or prohibiting chickens in your community, or allowing or prohibiting rentals or leasing. We can do a limited amendment. Your counsel, your legal counsel, can just do a limited amendment to the document, or to change quorum, or to change board member qualifications or something like that. You don't have to do the entire thing. Now, the key with limited amendments is while they are less expensive because you're paying for a smaller bit of work to be done, it's going to cost you more effort and more money over time because you're not amending everything at once, right? Which, budget for it. That's really the important thing. The key, though, with the limited amendments is you have to keep track, again, not only of which ones you can't enforce, which provisions, but then which ones you've amended. And so it can kind of get out of control. If your association documents are over 10 years, I would start budgeting to do some type of amendment or rewrite, unless there's a specific provision you want to do. If your documents are over 20 years old, there's probably a lot of things you can no longer enforce. So at the very least, have your attorney do a document review, which it's not a full amendment, so it's less expensive, but it'll go through the documents to tell you which ones, like which provisions you can no longer enforce. So that can be very helpful. Okay. Before Jenny wraps us up, we have stuff in the bag. Please help yourself. Okay.
I was going to say.
Oh, I'm sorry. Never mind. Forget I said that.
I'm just kidding. All right, so, I mean, this is all very self-explanatory, but best practices for getting approval. So making a wish list, identifying exactly what it is in the documents that's most problematic for the association, really explaining that to owners and ensuring that they understand why these amendments are necessary. Form a document amendment committee. So this committee can conduct even a initial review of the documents and identify the provisions that they think might need to be reviewed. They might be able to work with legal counsel to communicate regarding the provisions that are most problematic. The legal counsel or the committee can communicate with owners to effectively inform the owners why these amendments are necessary, like we talked about earlier, and then consult with the board to let them know all of their findings and what they think the appropriate next steps are. Next is obtaining owner input and feedback prior to the vote. So that's why we recommended holding an informational meeting with the owners, just to get a feel of whether owners are like extremely opposed to the amendment that's being proposed, or the things that the board is considering prior to expending association funds on them. This could be done by like a Dropbox of, owner suggestions on the association website or through an informational meeting, as we already discussed. And the association should make it easy for owners to vote. So this is why we generally, with amendment and restatements, recommend the mail ballot process, because not only does this not require the association to hold a meeting and obtain a quorum in person, but it provides owners up to 60 days to return their ballots. So this gives the board time to, I don't want to say hunt some of these owners down, but encourage people to return their ballots to obtain the requisite owner approval. All right. And last, as Amanda said, we have a bunch of goodies in the back. Please take them so that we don't have to take them back to the car. And does anyone have any questions? Yes?
I have a question on limited amendment. Say you're amending something in your rules, and you have your rules on the website. How would that limited amendment show?
Yeah, so rules are a lot easier because they're actually just approved by the board unless your governing documents require otherwise. But you could just upload a revised copy of those rules in full, as opposed to a limited amendment like in a separate document. You could just upload another full copy of those rules reflecting the information that was amended.
Okay.
Yes. Yes?
Where do we turn these in, or do we have to send it to the city?
To
Betsy.
Betsy. Yes.
I have some questions on House Bill 26-1099 beginning of the meeting.
Okay.
First of all, what's the purpose of this bill?
Of 26-1099?
Yeah.
Sorry, I didn't hear the first part of your question. So it had two purposes. The first was to to require the developer, the declarant, to do a reserve study prior to turnover. This bill started, when it was initially drafted, it actually had a funding requirement stating that the declarant was going to have to contribute, thank you all for coming if you want to head out, had to contribute 1.5% of whatever the reserve study projection was, because a lot of associations, when they start their association, when it turns over to owner control, they're finding that they don't have assessments or funding set up to maintain the association, right? And the homes tend to get sold with lower assessment rates to help move the properties. So the bill initially began as a way to get a developer to, one, have a more transparent study about what it's going to cost to maintain the association over the life of the components, and two, to require that funding. That part was stripped out of the bill, so the end result of the bill for the declarant part ended up being that the declarant is just, they're required to do a professional reserve study by a certified reserve study company prior to turning over control to the owners, and then provide a copy of that reserve study to all new owners. And then moving forward, that reserve study would also be included as part of the annual disclosures the association has to maintain and provide to owners. The second part of that bill, which had nothing to do with the reserve study, was initiated because there have been complaints about certain management companies not turning over documents in a timely fashion. And so the second part of this bill was to impose requirements under Kiowa that would require a management company, once an association terminates or chooses not to renew the contract, to forward all of the association's property, bank account information, passwords, assessment histories, ledgers, all of that to the new management company or to the board if there was not a new management company, in order to keep business going.
So what would be the requirements of an association that's not transferring management or selling? Are there any?
No, so if you're an association that does not have a management company, then that bill isn't going to impose a requirement on you. It's that part of the bill is purely to management companies and managers of associations.
Okay. One more question. Is there any language in that bill that requires a normal association who's not selling the property or anything like that to do a professional reserve study, or they can pay for it, or they can still do their same old method within their own reserve?
Yeah, so that bill did not affect the association itself obtaining a reserve study. The association is still required to have the reserve study policy and the investment of reserve policy. And then the reserve study policy sets forth how often the association will obtain a reserve study. But under Kiowa, the association can either contract with a professional reserve study company to do it, or they can do it on its own. So this bill did not affect that part of associations for reserve studies.
Okay, thank you.
Other questions, comments, concerns, emotional outbursts? Go ahead.
How enforceable is a maintenance matrix that has been voted on by the association passed?
So it depends on how it was done. So how enforceable is the matrix? The maintenance and insurance chart, the matrix, should be based on the declaration. The declaration is the part that's enforceable. The matrix is purely to give clarity and make it a little easier to figure out what the declaration says because it's in more of a chart form. Sometimes, however, people have done the maintenance and insurance chart as part of like an amended and restated declaration, in which case then, even though it's still based on what your declaration is, it's part of the declaration at that point. So in the first instance, where it's just based on the declaration, the maintenance and insurance chart itself isn't enforceable, but those provisions that are pulled from the declaration are what's enforceable.
That's what Melissa did for us.
Yeah.
So it's enforceable.
Yeah, so, and it's based on the declaration, right? So if it says owners insure the patio, then it's because there's authority in the declaration to require owners to insure the patio. Thank you for coming.